Court dismiss Rivers State emergency case against Tinubu. Justice Omotosho drop heavy judgment. This na Sinok Media, the channel when they report the news and they make them simple for everybody to understand. We dey thank una when dey view us. Abeg subscribe if you never do so. Put on your notification bell. It go ring once we drop update. Like, comment, and share our video. My people, how far? Welcome back to the channel where they give una correct political gist, analysis, and breaking news where they shape Nigeria destiny. Today matter na one serious court judgment when Federal High Court for Abuja just drop, and it is scatter talk everywhere. Na about the wahala wey burst after President Bola Ahmed Tinubu proclaimed state of emergency for Rivers State on March 18, 2025. That emergency proclamation shook the whole nation because it led to the suspension of Governor Siminalayi Fubara and even the entire Rivers State House of Assembly for 6 good months. Plenty people vex, say e no dey constitutional, say na attack on democracy. But 5 people, led by Belema Briggs, carry the matter go court. Today, Justice James Omotosho don finally drop in judgment. And my people, the judgment get plenty angles. Make we break am down small small so na go sabi wetin really sup, the political implications, and wetin fit happen next. First, make we rewind back small. On March 18, 2025, tension for Rivers State don reach boiling point. Crisis dey between Governor Fubara camp and the camp of the lawmakers when many dey say dey loyal to Wike, im predecessor. They fight over commissioners, control of the state assembly, and wahala about who they really dey in charge don nearly turn Rivers State into war zone. President Tinubu waka enter with executive powers, declare state of emergency, suspend the elected governor, and even the lawmakers. In talk say if he not act quick, Rivers fit collapse into violence. But many Nigerians ask, say president get power to suspend the elected governor just like that? Not be military regime we dey again o. Na that kind question make Belema Briggs and 4 other plaintiffs carry case go Federal High Court Abuja. Dem dey challenge Tinubu emergency proclamation, say e dey abuse democratic rule and e dey violate fundamental human rights of Rivers people. Now make we enter today's judgment by Justice Omotosho. The judge look the matter, shake head and talk say, local standby, who get right to sue? Justice Omotosho talk say the plaintiffs not even get legal standing. Dem not be governor, dem not be lawmakers, dem not be state executive members, dem not show any injury wey pass wetin other Rivers people dey suffer. Plus dem not carry flight. That na authorization from the Attorney General of Rivers State before dem file the case. Jurisdiction wahala too. The judge also talk say this kind case na constitutional matter. E no dey Federal High Court power to handle am. Na only Supreme Court get the final authority to decide such dispute between state and federal government. Tinubu excuse when dem not challenge. Tinubu talk say im declare the emergency to avoid looming breakdown of law and order. The judge observe say plaintiffs not even challenge that reason. Dem just dey argue about rights violation. Also, the fundamental rights claim when the court dismiss. According to Justice Omotosho, the plaintiffs talk say Tinubu emergency order violate their human rights. But the court talk say no, because Tinubu invoked the proper emergency powers law, and that one dey constitutional. Finally, Justice Omotosho called the whole case frivolous and baseless. He said the plaintiffs not get mandate from the Rivers people to go fight that kind battle on their behalf. With that one, he dismissed the suit. Now, wetin this judgment mean politically? Number 1, e strengthen Tinubu hand. The president now get legal backup, say the emergency proclamation stand gidigba unless Supreme Court overturn am. Number 2, Governor Fubara and the suspended House of Assembly members still dey on hold for 6 months. Dem future now dey hang because dem no fit return until the emergency expire or Supreme Court give different judgment. Currently, though, the 6 months don expire, both Fubara and the legislators don resume their duty. Number 3, e raise serious question about democracy for Nigeria. If president fit suspend elected governor with emergency order, wetin remain for states autonomy? Today na Rivers, tomorrow fit be any other state. Number 4, the judgment also show say ordinary citizens not to get power to challenge big constitutional moves unless dem get proper standing. Na lesson be this: if you wan challenge federal government for constitutional matter, e better make you dey Supreme Court direct or get authorization from state executive. But my people, e get other deep angles wey Nigerians suppose watch. Legal angle: even though court dismiss the case, Justice Omotosho still open window. E tok say na Supreme Court really get power for dis kind matter, meaning say if Rivers State Attorney General or even the House of Assembly carry am go Supreme Court, wahala fit still dey. Political angle too: Fubara camp go see dis judgment as big setback. Dem don dey hope say court go nullify Tinubu emergency order make Fubara bounce back as governor, but the thing no favour dem. Meanwhile, Wike camp go dey jubilate because dem go see am as another chance to hold Rivers tight. The issue of public reaction angle: ordinary Nigerians dey vex. People dey ask why emergency dey last 6 months, why president get power to suspend elected leaders. Dem dey fear say e fit turn to dangerous precedent. And of course, the historical angle: for Nigeria history, emergency rule no dey new. Na so dem do am for Plateau, Ekiti, and Ondo before, but e always dey controversial because emergency rule dey look like mini military intervention under democratic government. Analysts dem dey question why the judgment dey come now when the 6-month suspension wey follow Tinubu emergency proclamation don already expire. Nigerian court processes dey slow. Dem dey follow procedures: filing, motions, adjournments, hearing, arguments, counter affidavits. Dis case begin since March, but e no reach judgment until October. By then, the emergency suspension period don finish. For sensitive cases like dis, courts dey tread carefully. Dem dey look all legal angles well before dem deliver verdict, so e no go look like dem dey play politics. So judges no dey rush political matters. The judgment still important even after suspension. Although the emergency order don expire, the plaintiffs still want court pronouncement, so history go record whether Tinubu act lawful or unlawful. If court gree with dem, e for set precedent for future. But Justice Omotosho tok say dem no get standing, and na Supreme Court really fit decide such matter. Sometimes government dey benefit when case drag until action wey dem challenge don already expire. By then, judgment not fit undo the suspension. E just become academic exercise. But legally, court must still pronounce on am to close the matter. So in short, judgment delay no mean say case dey irrelevant. Na just normal Nigerian judiciary slow speed combined with the fact say only Supreme Court suppose settle am. So my people, na so e be. Federal High Court Abuja don finally close mouth for the Rivers emergency case, but the timing and the judgment dey raise more questions than answers. E show us say for Nigerian democracy, sometimes politics dey move faster than justice. By the time court go talk, the suspension don already end. But lesson still dey inside. If you wan challenge federal government for constitutional matter, make sure say you get correct standing or carry am go Supreme Court straight. Otherwise, you fit waste time and money for nothing.